would like at least one law enforcement person on there, only for the knowledge base. But then I think that we need to have an outside entity prosecute the AG, Attorney General, because this is a small town. And for us to think that we can come along as a district attorney one day, shaking the hand of the chief, and the next day prosecuting him, I don't know who we're fooling there. It's just not going to happen. So, and I wouldn't want to be in a position to do that, because it doesn't help the relationship between law enforcement and the DA's office, and we've seen that with the prosecution of Douglas and Zanotti, and that actually hurts all of us and compromises public safety.
Thank you, Ms. Bryson. Does anyone wish to do a 1-minute rebuttal or make a statement?
No.
Go ahead. No. No. Okay. So now we're going to get things were a little bit more kind of under control, because all these other questions were prepared in advance. The candidates have had a chance to see them. Now we've got some questions here from the audience, and each candidate will be allowed 2 minutes on each question. Will you tell me? I'm trying to translate again. Would you tell the audience how you believe plea agreements should be handled given the financial constraints of the court system? Ms. Jackson?
Well, I believe this pretty much dovetails into the first question that we were asked initially, how I would handle plea agreements. All agreements should be based, well, first of all, there's a difference between plea agreements with respect to misdemeanors and felonies, and plea agreements with respect to serious felonies or violent felonies. Serious and violent felonies, the plea bargaining is drastically prohibited, you can only do it under certain conditions. And those are whether or not you have insufficient evidence, whether or not you lost a material witness, or whether or not the punishment is substantially different than the original crime. That's not my law, that's actually was a law passed by the people of the state of California on June 6th in 1982, and has been the state of the law for the last 28 years. I would, in fact, follow it in every respect, because that is the law. Thank you.
Thank you, Ms. Jackson. Mr. Hagan.
As I recall, the question goes to plea bargaining, given the financial condition of the courts. That's a very difficult question to look at, because what you're doing is balancing two things that don't really fit against each other. You're supposed to be doing justice, and justice is supposed to be based on the fact that you have and the ability to prove something to a jury of 12 beyond a reasonable doubt. Then you've got the idea of what the punishment might be for the crime under those facts, and what you can plea bargain given the strength of those facts. And that's what justice is supposed to be about. This is discretion, this is how you analyze things, this is how you come up with what you think you can negotiate with the other side, given the tools that you have and the form that you're going to be in. To balance that, on the one hand, against the financial constraints of the court, runs counter to the idea that justice should be done according to law. Justice is not supposed to be done according to the state budget or the court's budget. Justice is blind, she wears a blindfold, she has a pair of scales out in her hand, she isn't looking at her pocketbook with one eye open. Nevertheless, we're dealing in these types of situations, we have to take it into account. So to the extent that you're ever wondering about whether you should plea bargain something or not, it would be a small factor, if anything, as to ease the load on the court system. But again, that would always be checked by the idea that public safety is the primary concern. What you've got to do is deal with the facts that you have, the evidence you can get into court, whether or not you can convince a jury, and then, if you can do that, the strength of your case to plea bargain with the other side and to get the judge to accept a sentence. As was mentioned earlier by Ms. Jackson, misdemeanors are quite different from felonies. Felonies have an entirely different sentencing structure. You'd have to take that into account as well. So it becomes a very difficult question to answer, so if I had to fall back on anything, it would simply be do justice according to the law under the facts that you have to deal with.
Thank you, Mr. Hagan. Ms. Bryson.
We only have 5 criminal courtrooms. We have more than enough cases coming through. And plea bargaining, I believe Mr. Allen said 90% of the cases are plea bargained. Plea bargaining is a fact of life. Without it, the courts would be clogged. And I guess our state would already be in complete bankruptcy. So what comes into play is discretion of the people's lawyer. To be able to look at a case and know its value based on the factors that Mr. Hagan mentioned. Can you prove it beyond a reasonable doubt to 12 people in a box, or can you not? Now, misdemeanor cases where there's victimless crimes, they can be pled out, still get a conviction, and move the cases along, and not clog the courtrooms and waste taxpayers' money. Because there's nothing worse than watching my officers holding their reports in their hands along the hallway when they should be out protecting us, waiting around for a hearing that could have been resolved if only lawyers could play nicely. And often it's overtime for them, so I can hear the sound of money being flushed down the toilet as I watch my officers standing idly, clutching their reports. So yes, we have to plea bargain misdemeanor cases. What I'm seeing is that misdemeanor cases, they're going full board in Mr. Gallegos' office to get experience for themselves, because that's what he's teaching them. You need to take more to trial, get good experience. Well, it's not good experience for the defendant, of course. It's not good experience for the jurors who are not making money when they're sitting there waiting. It's not good experience for the courtrooms. It's not good experience for the taxpayer. Now, on the other hand, the felony cases, they're being pled out inappropriately. So
Thank you, Ms.
everything's topsy-turvy at this point.
Mr. Gallegos.
Thank you. We cannot look at the budget in resolving cases. There are three things that we look at in all criminal cases and working towards dispositions. The first thing is, are there legal issues? Second thing, are there factual issues? The third thing, are there equitable issues associated with the defendant? Those are the only three things you should look at. Those are the only three things we look at. The next step after that is the priorities and the resources available, which means, from my perspective, the first and foremost is public safety. If it is an individual, once again, that is dangerous to this community, poses the risk of harm to this community, then that's a priority. So we cannot try all cases. It simply will not work, ladies and gentlemen. We have 5 courtrooms, 52 weeks in a year. And if a trial only takes 1 week, that's only a little bit more than 250 cases a year. We file over 10,000 cases a year. The thing is, how do you resolve it? And we seek to reach appropriate disposition. I also want everyone to know that the courts oversee all dispositions to make sure they are appropriate.
Thank you, Mr. Gallegos.
Thank you.
Going, following along with it, with some more of the questions from our audience.
Pardon me, will there be any rebuttal?
Would you like to, please?
Yes, I will.
1 minute.
Thank you. First of all, if you cannot prove a case beyond a reasonable doubt, you have absolutely no business in charging it. If a case then subsequently loses evidence, there are state bar rules that require a prosecutor to dismiss that and not take just simply a plea as an extortion attempt. You must dismiss the matter. However, I will tell you that a district attorney does not have the discretion to ignore the law that the people of this state passed 28 years ago. By initiative, they passed the Victims' Bill of Rights, which amended Article 1, Section 28D of the California Constitution. And it expressly provides that plea bargaining and serious felonies may only occur in certain cases. And I can guarantee you one of them is not judicial expediency, and it is not the expediency or the ease of burden on the district attorney's office.
Does anybody else wish to make a rebuttal or comment? So let's move on to the next question.
I do.
I'm sorry, go ahead, Catherine.
Ms. Jackson's word extortion is quite fitting. I would like to ask Mr. Gallegos why he's allowing his misdemeanor deputies to do that extortion, to get the most quote-unquote out of a case, when the facts clearly state that they can't get a conviction beyond a reasonable doubt. And why is he training his deputies to go to trial to get experience for themselves? And I know this because I was one.